police, but even human rights.
One day right there in Alabama, little black boys and black girls will be able to join hands with little white boys and white girls as sisters and brothers. I have a dream today.
And always feel that your life has ultimate significance.
Welcome to Civil Action. What a treat. Today, we have a very unique situation. We have an attorney who actually was a part of one of the most prolific criminal trials in, I would say, our city's history. I had the pleasure of meeting him many, many years ago when he worked for the district attorney's office in the city of Pittsburgh. Great guy, you know. You sometimes have an opportunity to meet someone that you really believe is ready to do good. You know, in the prosecutor's office, you know, you have a lot of power. You have sometimes the ability to change someone's life, either good or bad. And how you yield that power in a lot of ways, you know, is a determining factor of the person. I'd like to introduce my colleague, John Fodi. He presently works for Lee Tishman. He was a former DA, former prosecutor, great guy, I believe 15 years as an attorney. And I was scrolling through my LinkedIn page and I happened to see an article that he posted detailing his experience with the Antoine Rose case. And I'm going to tell you, you know, when I read that post, and we'll show you that in the article when we present it. But when I read that post, it compelled me to call him, because very rarely in our city's history do you ever get an opportunity to sit down with a prosecutor and reach into their mind and get a perspective of what they were thinking. Well, John, in true form, has agreed to sit down with me today, and through this conversation, you'll get a chance to hear what his thoughts were and all of the compelling things that surrounded such an important trial in our city's history. So with all that, I'd like to introduce Mr. John Fodi to Civil Action. How are you, John?
Doing well, Todd. Thank you for having me.
Man, I was so excited, you know, when I got word that you agreed to, you know, talk with me today. And I want to read something that you posted, and I want to tell you some of the things that caught my eye. What you said was, on June 19th of 2018, Officer Michael Rosfeld shot and killed 17-year-old Antoine Rose as Rose fled from a vehicle Rosfeld had just stopped. In the days that followed, over the next 9 months, I worked alongside law enforcement officers, prosecutors in Allegheny County to do one thing. And that one thing that you said has resonated with me since the moment that I saw it. And you said to get it right.
That's right. That was the job. The job was to get it right. I appreciate that you took it that way. That's the way I meant it. That's the way I think prosecutors should do their job. That's the way I think defense attorneys should do their job, and courts as well. And that post was written on the heels of an incident that I didn't think people were working hard enough to get it right. And it just harkened back my memory to the Antoine Rose case, and a time when I felt like all I did for a year was everything I could to get it right.
Well, before you talk about, you know, the Antoine Rose case, tell me about what led you to this journey to become a prosecutor.
So I don't know, like many or maybe some, I found myself in law school not knowing exactly what I wanted to do. I wasn't in the top 10% of my class, so I wasn't going into big law. But there was something about being in a courtroom that really spoke to me when I was in law school. I really enjoyed oral argument, just for that purpose alone, I liked making my point in court, and I liked taking questions from a panel of judges in that scenario, and being able to work with those questions in hard situations to try to come up with explanations that were beneficial to my side. And I took I took an internship with the DA's office. I worked under now Judge Bruce Beamer initially. He was in the general trial unit, and I worked some cases with him. And there was something that just struck me right away about the job and the import of it. And at that time, working under Bruce and alongside the other attorneys there, I just had a lot of respect for what those folks were doing. And I felt that, frankly, I could do the job the right way. I think you said in your introduction that you wield a lot of power when you're an assistant district attorney, even a young prosecutor, fresh out of law school. What seem like small cases compared to the one we're talking about are really important to a lot of people, victims
Absolutely.
and defendants. And as the prosecutor, you're in control of a lot. You're not in control of everything, but you're in control of a whole lot. And I have to say that for the most part, the folks that I work with seem to grasp that. I hope that I embody that as well when I was there. But I found it to be a very rewarding job, because I could do what the public required of prosecutors, and that's prosecute cases. It's important. It keeps communities safe, but also not abuse that power. Realize that you do not have to push hard on every single charge that's brought before you. You are to also hold the police accountable to make sure that the charges are correct. You are supposed to continue to review evidence up until the moment of trial. And then at that point, I still believe in the institution. I believe that the prosecutor should push hard, as should the defense attorney, and that's how justice works. So there was just something about that venue and this institution that we work in that really resonated with me. It was a low-paying job. I was in a ton of debt, but I walked across the 10th Street Bridge, and I had fun, doing my job. I felt like I was doing good and having fun at the same time. And so for a long time, it was something I really enjoyed doing, and I had the honor to do for 11 years.
Yeah, I'm very familiar with Judge Beamer. I've known Judge Beamer for my entire career, and he does it right. I have nothing but respect for him. For those that don't know you, and I know you because I had some cases with you. In fact, I remember when you first started. But for those that don't know you, and I think this is important for context, you started at the DA's office, per my understanding, at a very young age. Is that true?
Yeah, I went straight from college to law school. So, approximately 7 years after you graduate high school. So I would have been about 25 years old, or thereabouts, 2008. So yeah, I was pretty young.
25 years old. Now, I didn't go to law school until I think I came out when I was 27. But to be 20 in your 20s, let's say your mid 20s, and to have a badge and to be given the responsibility of prosecuting cases and using your own judgment and trying to determine, what the best path forward is, it's a heavy job. It's a heavy job. And I want folks to understand that, because, you were doing, a lot of important work. And I doubt you knew, I guess when you first started, that you would be part of such a prolific, demonstrative case as the Antoine Rose case was. Is that true?
Of course it's true. Yeah, I don't think you know where your career is going to lead when you join the office. I had my first felony gun trial, I think, just over 6 months out of law school. And, nobody got hurt, but it was a gun possession charge, and a young man's, liberty is at stake there. And so looking back at that time, when you're 25, you're out of law school, you probably have your confidence about you, and you're ready to go. You think you're ready to go, but almost 20 years later, I realized how young I was. We refer to ourselves as baby lawyers back from the time when we were just beginning practice. And I think that's apt. I don't think you quite appreciate everything that's in front of you, no matter what area of law you get into. But certainly as a prosecutor in a county this large, you have a lot on your plate. It's not an exaggeration to say, and you saw us, we would walk around with our files every day, 8 to 10 cases a day, bouncing from courtroom to courtroom. And every one of those cases could have been something from simple possession to a DUI to something more serious. But I didn't know then the trajectory of my career. I didn't know where it was going to take me. And eventually I found myself in the investigations and grand jury unit, which handled what were typically either high profile cases, complex cases, white collar cases, and then we also handled police prosecutions. There weren't, countless of those, but probably myself and maybe one or two other colleagues were the only ones that kind of over time got tasked with those. Not for any particular reason. I think it's one of those situations when you've been asked to do one and you handle it well and professionally, the boss asks you to do it again, right? So
Right.
I handled a few of them over time. I think prior to the Rossfeld case, probably 2 to 3 police prosecutions before that. So I'm referring to prosecutions of police officers, and they were extremely hard, extremely hard, both just to prove your case, to get through the case, the pressure you feel from different places, because you work alongside police officers when you're a prosecutor, and they treat you and understandably look at you somewhat as a colleague. You're on the same side of the V in Commonwealth versus.
Sure.
So I think that when you start handling those cases, you have to understand that you're sticking yourself out there a bit, and you have to handle yourself appropriately. But even then, when I handled those police officer cases, I didn't know, and none of us could have known what was going to happen between Michael Rossfeld and Antoine Rose that night, and who would get tasked with it. When that happened, the news broke, and I didn't know until the next day when I was brought in, and I kind of knew what was happening when I was brought in the front office. Kind of knew what might be a play. It wasn't an assignment that I had to accept, but I mean that from the office's standpoint, it's a heavy thing to ask of somebody. But to be honest, I think that maybe in my mind, I did have to accept it. I think that there was something that I knew how hard it was going to be. Maybe I didn't. Actually, I think I was a bit naive about how hard it was going to be on me. But I felt like I had to do it. Yeah.
That's kind of the thing that I wanted to get into, right? I knew that, this was going to be, such a big opportunity between you and I. And I remember, I started practicing law, back in 1994 is when I passed the bar. And, it's every young lawyer's dream to take on a high profile case. And obviously, like you said, you have to show some proficiency in what you're doing, to be trusted with more serious cases. And I can't actually say that, in that interim of time, within 10 years of me first starting, that I had a high profile case that I knew I was going to ultimately take to trial. But you started, in the office around 2008, and you took on this Antoine Rose case, in 2018. So you had been a young lawyer, for the most part, for 10 years. And now you're handling one of the most divisive, criminal trials in our county's history. I mean, I can only remember a few times at best when I've ever seen a police officer be tried, and I never saw a case that was more important than your trial. And I can remember, watching the news clips on TV. I remember, the newspapers, the city was kind of preparing for, what they expected to be, protests and, a lot of, pretty gory stuff. And now here you are, and I want to hear a little bit about, exactly what you felt in that moment when you realize, that everything that you had seen on TV, everything that had been in the papers, because it had been in the papers, countless times. And now here you are, and you're going to be, one of the lead lawyers that's prosecuting a police officer on the same side of the V as you have been on for 10 years.
Yeah.
Tell me about how that made you feel.
I think I'd be lying if I said that I realized how big it was at that time. I think that maybe part of what made it I don't want to say easier to accept, but I knew it was a big deal. It was an exciting and tense moment at the same time, Todd.
Did you ever fear for your personal safety? Did you think maybe, you know, I'm going to be driving down the street and potentially get stopped, and I'm going to have somebody that's not happy with the fact that I'm doing this against one of their brothers or sisters or whatever, and
I
did you
did.
feel? Yeah, tell me about
Yeah, I
that.
did.
That
I did.
feeling.
I mean, some of that came over time. We know now at the end of the trial, the defense attorney, Pat Tomasi's office was shot at. Nobody inside at the time, but certainly not acceptable and scary. Near the trial, I had a police unit on my street daily, not 24 hours a day, but certainly I'd see them roll down my street, and it was a kind of a one-way in, one-way out street. So I knew they were there for me. They weren't there regularly. That even though that helps you feel a little safer, it also brings a little bit of flutters to your chest about I have a very young child at the time and a wife inside, and what am I bringing upon them? And then
Yeah.
yes, also the kind of the brothers in blue, I guess, that might look at me differently, look at me sideways about how did you get here? I think some of what helped get over that angst or that potential angst was the fact that this wasn't just me or just me and another prosecutor or even a prosecutor's office. There were police officers on the other side of this, on our side, I guess, of the V that had to bring the charges, right? This wasn't filed by the district attorney's office. This case was filed by the Allegheny County Police Department Homicide Division.
Sure.
And it was filed by professional, respected detectives. And so having folks like that who wear the badge out on the street and have done that job file that charge helps. It helps, bring some comfort. But nonetheless, sure, I felt scared. Not scared in any one moment, but I had that in the back of my mind that anybody might be displeased with how I'm handling this. Yeah.
Yeah, yeah. There were barricades on the streets, and
Yeah.
people were trying to make the public kind of calm down and let the process work. And
Yeah.
I can recall there was a lot of doubt as to whether you or the other prosecutors were really invested in securing a prosecution, or whether this was just like for lack of a better word, a publicity stunt. And that's, I think, what captured me when I had an opportunity to read, your post, because in that moment I got a chance to look into your feelings, and then I said, man, this is powerful. And this is, the next question that I want to ask of you is probably something that might be the hardest thing to talk about during the course of our meeting today. But I'd like you to take me into, the room. You don't have to tell me about names and people who authorize this and that, but in the room, what were your thoughts about how or what information that you needed to be able to convince the jury of to secure a conviction?
When you say in the room, do you mean by the time we got to trial or at the time we were making charging decisions?
At the time that you're making the charging decisions,
Sure.
in your case prep, your interviews with witnesses, your conversations that you're having with various detectives who are presenting information to you, you're kind of taking all of that in, and you're trying to determine whether you have enough. Do you think a jury will believe this or likely to believe that?
Right.
What are some of the conversations that you had with your colleagues that led you to make certain decisions based upon whether you believe that you get a successful outcome?
Right. Yeah, it's absolutely a fair question, and I'll probably caveat it up front for my answer that from my review, and you mentioned that prosecutors don't often speak after they're even out of the public service sector, but those charging decisions are probably one of those areas of ethical boundaries where I do have to be mindful of those decisions and how they come about aren't part of the public record, right? They're not going to be in any filing other than the fact that we filed. But I think that I can answer some of it nonetheless, right? I think that I can say that at the highest level, whether you take me to be the type of person you read in that LinkedIn post or not, I hope that you hear my voice now that I came away proud of how that that process was handled. That, let's call it that 4-day process. What I found that process to be was exactly what we would expect of any prosecutorial agency in any case, how big or small, whether a police officer is at issue or not. I think that it's fair to say, without breaking any type of ethical rule, that it was an information gathering process. It certainly does still come down to judgment calls, right? What charges to file, if any, and what's appropriate. But if there were baseline standards that came across in my mind, it was that we were looking to have as much information as possible from every witness, from every camera, good, bad, otherwise, at our disposal. Because, and this holds true for all cases, whether you're defense or prosecution, you don't want to be hasty in your decisions and find out later that you were dead wrong about something. So we didn't want to, be caught off guard after making a decision, no matter which way we had went. So it really was an exhaustive effort to gather information. And it was also, I think, a drive for consistency. And what I mean by that is, even though a police officer has different standards that they're subject to with use of force versus maybe a civilian using force on another human being, we didn't, in my opinion, want to give the impression that the status, and I don't mean this in a negative way when I say give the impression, we didn't give weight to the fact that he was a police officer beyond the statutory requirements of what does it take to overcome a justification defense in use of force cases. So other than that, I don't know if this is going too far, but I don't think it is. I would say that the process there, again, was to get it right. And regardless of the outcome, I mean, the outcome should matter, and prosecutors shouldn't bring cases that they don't think they could win. That doesn't mean you have to, only bring the easiest cases. You should bring cases when you believe it's the right thing to do, knowing that you have a heavy burden and that you will face somebody else on the other side of this. But I think the idea there was get it right. And I still believe that we did do that. I believe that we got it right by bringing this case.
Now, you can tell me you can't answer this question, and I'll accept that. But one of the things that I think concerned a lot of people, and I have to bring it up, is the fact that you guys, for whatever reason, did not call an expert witness. And for the viewers who may or may not understand the role of an expert witness, but I just want to say what that person does. An expert witness, guys, is somebody who probably works in law enforcement, has be either trained police officers in the use of force. They understand when it should be used. There's a criteria of when force should be used, and normally that person comes in and they give an opinion as to whether they believe that the officer that is being prosecuted used more force than what was necessary to effectuate an arrest. Now, in the Rose matter, no expert was called. Are you able to talk about why you guys didn't call an expert witness?
I don't know that I am. I don't know that I am, Todd. I mean,
that's fair. That's fair.
I truly do want to answer. I don't think I actually don't think the answer would upset anybody who doubted us in that. But I also understand the doubt, because looking in hindsight, you wonder, could it have made a difference? But how that decision came to be isn't something that made public record, right? And because it didn't make public record, I don't think that I am allowed to go into that detail.
Okay.
I can say this. I'll give you one answer, though, that I can say that they called the defense expert, former trooper Cliff Job, and his job, like you said, was to say this use of force was sufficient. Alternatively, we could have called another use of force expert, likely also another police officer or somebody that trains police officers, and they would have said this use of force was too much. In hindsight, might that have mattered to the jury? Maybe. There was also some thought, and I think for good reason, to say we can use the defense's efforts to hire someone, to pay someone, to come in and say these things against them by saying, look at the video with your own eyes. Look at the language of the statute. Look at the video with your own eyes. You do not need somebody to tell you this is right, wrong, or otherwise. Now, I can sit here and argue it the other way too. Sure. Sitting here today, I wonder how it would go if it had been another. But in this battle of the experts, the fact that we didn't have one did not dissuade me from the fact that I could go hard at the defense expert and use the defense's kind of hired gun, so to speak, against them. I think I scored some points with that. I think that Cliff Job overstepped in some areas, and I think that that came out in trial. But would it have mattered if we had an expert? It's hard to say. I don't know. I don't. But I wish I could have a crystal ball and tell you. Yeah.
Yeah. It's like I don't want to ask questions of you that sort of cross the line of what your ethical obligations are to your former employer.
Yeah.
But I'll just give you my own personal thoughts. Obviously, that I try a lot of civil rights cases. And I would say the majority of the time, we're looking at, is there an expert that we need to bring, to look at the facts and kind of educate the jury as to, whether this officer's, actions, were in line with generally accepted practices, right? And the concern always is that the other side will present one and we won't have one, and is a jury likely to think that the reason why we don't have one is because we can't say that officer's actions went too far, so I understand your dilemma. Let me ask you this question, all right? So you were, I don't want to say you were going up against, but the other side, was being represented by a great attorney. I mean, someone who's been practicing forever, Patrick Tomasi. And, he dots I's and crosses T's,
Yeah.
Did that at all resonate with you that, maybe you needed to do a little bit more, to counter, his very aggressive defense efforts?
1,000% it resonated with me. The other prosecutor on my case was at the time Chief Trial Deputy Dan Fitzsimmons, and Dan's style had always been very methodical, almost professorial. When we talk about dotting I's, Dan is the ultimate, dotter of I's. He doesn't leave a stone unturned in his cases, and he had a long, successful career because that was his style.
Absolutely.
But theatrics was never his style, and to be honest, I wouldn't say that was my style as a prosecutor either. Mm-hmm. However, with the prominence of this case and the opponent, so to speak, in Mr. Tomasi, I knew that I would have to channel something a little bit different. I knew that the firepower in the courtroom from Patrick Tomasi had to be matched in some way. And so my preparation for this case and my two prominent roles, I guess my first was kind of lead picking a jury. The second was cross-examination of the defense expert. And the third was closing arguments. But for those latter two, I had to channel something a little bit more theatric in me than I'm used to and accustomed to. And I worked on that for months, Todd. I worked on it in an empty grand jury room on weekends in Dormont. I worked on it on my treadmill, listening to music that would try to get me pumped up, because I knew that I had to kind of rise to that occasion. I knew that it was a little bit different than my normal tact in court, which is approachable, right? We all have different styles that we have to be genuine to. And I think that my tact with the jury or the judge is I'm approachable. You can talk to me, and what I'm saying is going to maybe resonate with you because I don't sound like I'm full of it. I don't sound like I'm pounding my fist, and maybe I'm not the showman, but I'm approachable. So that's my norm. Right. But I couldn't bring just that here. I brought something a lot different, and I was really proud of what I was able to do. It was like coming out of my shell in a way, both in the closing and the cross-examination. I felt like I was a different person, but also a little bit like a little bit more of a superpower or something that I didn't know I had inside of me. And so, Pat Tomasi had to. he had to be matched in some way. And I'm not saying that maybe I could match him exactly. You're right. He has decades and decades of phenomenal trial experience, but I think I rose to the occasion in that moment.
Well, you did a great job, and
We didn't win though. We all know that, right? Yeah. So I don't know. Yeah.
well, I'm getting to that, but
Yeah.
winning and losing, especially for our respective sides, is sometimes tough, right? Sometimes you lose the cases that you think you'll win, and you win the cases that you never thought you had a chance.
Yeah.
In your case, obviously you guys did not prevail. The officer was acquitted. Take me through that feeling, when, because when I'm in the courtroom and I'm asked to stand, you know what I mean? I mean, them butterflies, they hit you like a ton of bricks.
Yeah.
You're nervous. You put decades and decades of preparation time into this, and all your family is watching, your friends are watching, and more importantly, you have this family, right, who's depending on you and counting on you to get justice for their child.
Yeah.
And you stand up, and then the verdict is read. Walk us through that.
Yeah. It was hard, and it came back fast. I mean, we weren't out very long. The jury was from Dauphin County. Closings were on a Friday night. I want to say I closed probably sometime around dinner time, and it was late that night when we were called back, and I was surprised that we were being called back. But when we were being called back that quickly, I started to get a feeling that it wasn't going to be a decision in the Commonwealth's favor, which I guess maybe some of the Band-Aid starts ripping off, because not that you're always right about that instinct. Juries can surprise you every time, I guess, but
Sure.
there was something about the speed of the verdict here that certainly started to feel like it wasn't going to be what we had been working toward. I don't know if I had an expectation, but working toward. I felt like my closing, in hindsight, and I still think it was the best closing I've ever given in my life. I think I tied ends together that the jury might not have been able to do on its own. I felt like there was a really good chance that we could have saved a very tough case from a full acquittal. But we did charge the highest charge. I mean, we charged it as murder in the first degree, and that we were climbing a high mountain. And we can talk about them if you want, Todd. I mean, there were multiple issues in pretrial, mostly in pretrial, that led to what was even a harder case than maybe it had looked like to the outside. But when they came back in that quick time, after what felt like about a year of work on nothing but this case, I think I might have had some other small ones, but it really felt like the year of my life to that case. It was hard. It was really hard. I got to know Antoine's mother, especially. She was in the court all the time. We talked all the time.
She's a beautiful person.
Yeah, I know there were times that she was displeased with decisions or other things. I mean, that's normal. That's part of the job. We as prosecutors, we face that a lot.
Right.
But it was still hard. It was still really hard, and I think I gave it everything that I could. I think I did everything that I could, and it's kind of hard to also say this, that the verdict also doesn't mean the system didn't work. I mean, the system may have worked the way it's, I guess, supposed to. It doesn't mean that we all agree with the verdict.
Right.
But it's that's one of the things that I guess you start to get, those calluses as a prosecutor or defense attorney, that you realize that as long as you didn't see something shady, didn't see something unethical, that everybody did all they could. Ultimately, it's not the prosecutor's decision. It's not the defense attorney's decision. And in this case, it was the jury's. And there were 3 African-American voters on the panel. There were women, there were men. They were from another county.
Right.
I felt like when they came back that quick, there was just something that I wasn't seeing, because I didn't think it was going to be that quick. Even if I lost, I thought it was going to be a couple of days for something so monumental. I thought even they would want a little more time, even if they had come to a quick decision, to say, well, we thought about it a little longer, but maybe 4 hours or so they were out and they were back. But, I can look at it also now and realize some of the monumental statutory issues we were up against and pretrial decisions we were up against that made this exceptionally hard, beyond what we all see in the news. And I think that's what's hard about a lot of our cases in criminal law. I do a little bit of defense work now. I get a lot of requests from family members and friends to opine on what do you think about this thing that happened in some other state. And I usually say I didn't watch it, but don't rush to decision. Don't rush to judgment. There's a lot more to it. And what I mean by that is there are witness interviews, there are statutory requirements, there are a lot of things that we can't pick up on just from watching a video and knowing what we think should happen. There's a lot more that goes into it. And here, I would say that fundamentally there were two major issues that made this case exceptionally hard that go way under the radar from what a cell phone video can ever show, right?
Well, let's talk about that. What are those two issues that you think had a major impact on the jury's decision to acquit?
I would say the two biggest ones, outside from the one that everybody knows, right? The one that everybody knows is that prior to Antoine running from the car and being shot in his back, he was at least in a car that had been involved in drive-by shooting just moments earlier. So unlike some other cases, there was something quite serious that happened beforehand. And there was no way that that fact wasn't going to become relevant to the case. So that's out there. That makes it hard as it is, right? Even though the law says we're not to, go there and blame the victim, so to speak, for what happened to him as he ran from that car, it's natural for a juror to maybe think about something like that. So we knew that was hard. But what made that much, much harder was I think one of the most incorrect pretrial decisions. But again, I wasn't the judge, so that's not my call to make. But it was the decision to allow into trial, and we actually ended up introducing it because we didn't want the defense to do it after us. It was the video of that drive-by shooting. And the key element in this case, Todd, the thing that I feel most comfortable talking about is the theory of this case, the theory of my closing argument, was that Michael Rosfeld had to be judged, his conduct had to be judged based upon what he knew and when he knew it and why he took those shots, right?
Right.
So it's fair to say that Michael Rosfeld knew that a car matching the description was in the area, and that car was likely involved in a very violent offense. That's all fair. But he didn't have a chance to watch the surveillance video that was mounted on the side of a convenience store, I think. And he didn't get to see all of that. And so at the very beginning of trial, this jury is being bombarded with not just the information that this is what Michael Rosfeld knows, but the actual video, the shell casings. And in fact, you see the hand of Zywan Hester was the young man who actually fired the shots, who was in the back seat with Antoine Rose. You see Zywan's arm come out of the car, and you see that gun being fired. And that's scary to see for anybody. And then you see another man pull out, just stand on the street, pull out a firearm and shoot back at the vehicle. It was a lot to absorb. And to me, allowing that evidence into trial was incorrect. I don't see how it could have been more probative than prejudicial. And prejudicial cuts both ways, too. Was it prejudicial to the Commonwealth's case? Absolutely it was. And was it probative? And my answer is absolutely it was not. There's no probative value because there's nothing that Michael Rosfeld could have seen at that moment when he pulled the car over. So I don't know if that is a good explanation, but I hope it is. But that video coming in was, I think, catastrophic in many ways because it sullied Antoine Rose is what it did. Even though he wasn't the shooter, it just showed something in such graphic detail that's hard to recover from. But the other thing that's not anybody's fault, but potentially legislators that need to get to work on it was at the time, the statute, and maybe still today, I need to look at it again, it allowed the use of force by a police officer on someone who is attempting to escape and the officer has a reason to believe that deadly force is necessary to prevent escape and that the person has just committed a forcible felony. Mm-hmm. So, and the definition for forcible felony is quite wide, and And also the officer that's trying to stop an escapee or an attempted escapee doesn't know everything yet. Michael Rosfeld certainly didn't know everything yet. And so the statute that permits deadly force in that circumstance became part of the jury instruction. I mean, and that is, if you think about that, I mean, did Michael Rosfeld have a reasonable belief that the person in this car was just involved in a forcible felony? That's a hard thing to overcome. And was
Right.
the person escaping? That's a little easier in my mind to overcome, because the use of force is supposed to be necessary to prevent the escape. And I made a grand argument about all the other things that officers can do to stop an escape before they pull a firearm out and shoot. But I understand that with that wide latitude for use of force, we were facing a pretty uphill battle when that's one of the last things the jury hears as they go out. So yeah, I think those are probably the two biggest things that I don't know that anything that you can say in a closing argument or anything would undo those two things. So they saw this video and they heard this instruction. I mean, you're battling those two things going back in that deliberation room, and who knows, that could have been that all it took is that instruction. And they said, what else are we going to do here? The guy was escaping and that was a drive-by shooting. I don't know.
Did you have an opportunity to poll the jury after their verdict?
No, they were taken back that night. I can't remember, one of them may have interviewed with somebody in the news. I tried to follow it for a little bit to see if anybody was talking about it, to see what they thought about it.
Right.
Yeah, no, I didn't. I mean,
So you never really got a chance to kind of get the jury's perspective as to why they deliberated and why they came to the decision that they came to.
no, I don't.
Yeah, that's tough.
I remember the foreman being probably my favorite person, and so having him kind of deliver the verdict, he was, I don't know, he was a black man, probably in his late 40s, early 50s, just so pleasant to talk to during jury selection. Just seemed like the type of juror that both sides just kind of want to have on a panel. And there was something else about him reading it that told me it was like, it was very real, right? Like when this man of character, I guess, so to speak, there was just something about him that emanated from him of like, this is a guy with just a ton of like strong character traits.
Right.
Him delivering that was also kind of, I don't want to say it was a blow. It was almost like it made it more real, more like he's saying it this quickly, then okay. I mean, that's just where we are.
Yeah, sure. I mean, unless you've actually done it, most people have no idea, just how tough it is to put everything into a trial and then walk away with, an unhappy result. It's tough, and I commend you. I commend you for a lot of reasons, right? But the biggest reason I think I commend you is the fact that you were willing to come here today and you were willing to talk about the hard facts, the tough questions, and even that post. And it's one of the next to the last questions that I have for you. But what made you, or what inspired you to write that post? I mean, it's 2026 now, right? So 18, there's two, I'm doing the math in my head, 8 years later, right?
Yeah.
You decide to go on to, can I say your LinkedIn? Oh, I guess I already said it, but your social, your LinkedIn page.
Yeah.
And you decided to wake up one day and you write this very long, articulate explanation about a case that most of us only got a perspective about what really happened from what we read in the newspaper or saw on TV. And here you are writing about it in complete transparency for everyone to see. What inspired that moment that you had?
So I think it goes back to the wanting to get it right. That post was, I want to say, with the day after or 2 days after Alex Preddy was killed in Minneapolis. And the rush to judgment in 2026 versus, especially, go back 2018 or earlier, but everybody rushes to judgment so fast now. But in that case, particularly, what really upset me was it wasn't just the peanut gallery. It wasn't just commentary on news stories. It was our government deeming Alex Preddy to have done things that we could see he didn't do on video, or
Sure.
calling him names that were worse than convicted of something, right? I mean, he was a domestic terrorist. He was, I can't remember the other names, but things that were deeming him guilty of something very, very serious. And so the effort to get it right wasn't there. I mean, you could, tell me that Alex Preddy did something that I didn't see, but get there first, right? I'm not saying he's,
Right.
yeah, I don't know what happened in that scrum there. I know what I can see on the video, but that video doesn't show me enough. And so when our government was not getting it right, it brings distrust to this institution that we serve, right? We serve in this institution of justice. And to me, I am able to, and I know you are too, able to shut out the noise, because you just don't know until you've been in these courtrooms, or, if you haven't been an attorney, at least sat on a jury at some point. I think those members of our public sometimes understand the gravity and the import of what it's like to be in that position, and realize that it's not everything you see in one camera that'll tell you the whole story. And so
Right.
when that happened, all I could think about was the Antoine Rose case, and the pressure that was there, and how everything was going to be done under a microscope. And it was. I mean, it was, every last thing we did was under the microscope. And in a way, I kind of like wish that could be done in every case, because that's the way it should
Sure.
be done, right? I mean,
Sure.
it should be done
Sure.
in the public eye. We can't do that with every case. That's understandable. But, with the Alec Preddy case, the rush to judgment was upsetting. It reminds me too, Todd, I was kind of thinking about talking to you tonight. I was thinking about my closing argument and kind of the case and the gravity of it all. It starts to come back to you a little bit
Right.
this many years later. And I remember getting up to Dauphin County, and I walked into the jury, or the big courtroom there, courtroom number 1, I think it was. And up behind the bench, they had this phrase in gold letters up on the wall, a big, beautiful, like, courtroom wall. And
Right.
it said, I might be paraphrasing this, but I think it was the first line of my closing statement. It said, "No man shall be deprived of his life, liberty, or property unless by judgment of his peers or law of the land." And I remember getting to Dauphin County. It actually brings a little bit of a chill to me, because this feeling was very real. I walked in that, and I don't think Dan Fitzsimmons understood how much it meant to me, but I said, "Dan, that's the beginning of my closing." Like, at that point, we knew I was going to be closing. And I said, and I don't want to say he rolled his eyes, but he was like, "Okay, okay." But it hit me like a ton of bricks. And in working a little bit today, looking forward to this interview, I said, where did that come from? I never actually Googled it back then. Where did that phrase come from? And it came from, actually, the Magna Carta. And it was one of the founding principles of due process. And it's so interesting to me, bringing this full circle, that what I was talking about, that LinkedIn post, and what that wall was talking about there, are quite the same, like, expectation that I have of this system, right? I expect that with the awesome power of our government and accountability that it owes to us as the public, that we follow the judgment of peers or law of the land. We follow that to wherever it leads. And I think that expectation is something that we have in every case. And
Sure.
in Minneapolis a month or so ago, that wasn't fulfilled. And so it prompted me to be willing to talk about, the Antoine Rose, Michael Rosfeld case, because I'm not a social media guy. I don't post on Facebook. I don't do Instagram. I play around the marketplace at best. And I really don't post much on LinkedIn. It's usually a share of professional, boring article. But it's the only place that I have a bit of a platform. It's the only place where I have a number of followers that might read my words. And it was important to me, because this thing that I believe in, this institution that's much bigger than me, in my opinions, I don't want it to just be thrown out and people don't believe in it anymore. I want it to persist into the future. And I don't know, I do that, I guess, for my kid, myself, my belief. I mean, I'm just kind of I'm a believer. I have to keep fighting for that thing, and it felt like it was the right time for me to speak up a little bit and put myself out there. I didn't know it would lead to this, and even an even bigger platform with somebody gracious enough to say, "Hey, let's talk about that case." And sure, it's a little, I guess, unnerving because it puts me out more than I'm used to, and I'm talking about a job that I did as a prosecutor. We don't see a lot of prosecutors talk about it, but also
Absolutely.
in my mind, why not? I mean, why not? I'm proud of the way I conducted myself during that time in my life. I'm proud of what I did in that case. Disappointed in the result, but I still believe in the system. So, that LinkedIn post led to something that spread a little bit, right? People were sharing it that I didn't know across the country, and that meant something to me. Yeah.
I gotta tell you, man, I'm proud of you too. I mean,
Thanks, Todd.
not that you need my, my whatever, but it's tough to do the job that we do. You know,
Yeah.
being an attorney and taking on responsibilities for the care and welfare of another, whether it's a victim or a victim's family on your side, or representing somebody who was accused falsely, and knowing that this person's life is going to be dramatically affected by what you do. And for those reasons, you take the job seriously. You spend the time that you need so that you can step into your client's shoes and give them the due process that the law it tells you they're afforded. And I know some lawyers don't take that as seriously as other lawyers do, but I get a very strong sense from having worked with you in the past, our conversations here today, and some of the things that I've seen over the course of the times that you and I have been practicing law, that tells me that you do the job right. And you may not have gotten the outcome that you were looking for, but nobody could ever point a finger and say that you didn't do it to the best of your ability. And for that, I want to thank you for coming here today, for putting yourself out, for being vulnerable, for allowing me to pick your brain and to, get your perspective, on something that the majority of us who are over 40, which I am obviously, remember. That case was a very important part of my life. It's probably one of the reasons why I became a civil rights attorney, and I'm proud that I had the opportunity to work with you. The last thing that I want to close with is people who didn't really have a chance to do what I'm doing now, right? If you wanted them to know anything more than what you've already said, right? All the great things that you've said thus far, what would you like to leave people with as a final word as it relates to this very, very important case in many of our lives?
I think if there's anything I want people to know is that though there was, an acquittal, I can say that not just for myself, but those that worked with me, the law enforcement officers, my co-counsel, Mr. Fitzsimmons, nobody mailed it in. Nobody took it soft. And we all worked hard. We all wanted to get it right. And that means a lot to me. That means a lot to me. I think that if I had seen anybody treating this case differently because it was a police officer or they had a predetermined opinion about what we were doing, I don't think I could have stomached it. I probably would have called it out and made sure that that person was no longer part of the case. But you guys get an opportunity to hear my passion for the case and what it meant to me. But the other folks that kind of also lost, I guess, so to speak, that night, for the Commonwealth's sake, I kind of want Michelle Kennedy to know. I want everybody else to know that it wasn't for a lack of trying. There's certainly judgment calls that people can make. There's certainly stylistic calls that people can make, and that all that criticism is absolutely fine. I'm okay with that. That's expected and reasonable. But but it wasn't for a lack of effort or passion for doing the right thing. And I think that's really important for everybody to know about the Antoine Rose case, is that everybody that was on the Commonwealth's case worked hard to do this prosecution the right way. And in many ways, more resources, time, effort were poured into this case to prosecute a police officer than the Commonwealth has the ability to do on any number of other cases. And yet we still lost. I mean, what that says about our system, I don't know, but I think that's important for me to tell everybody. I think that's important for the family of Antoine Rose to know. I think it's important for our community to know. It's not the right result maybe for some people in their minds, but they should know that it wasn't for a lack of effort or passion or belief in what we were doing. I think that's important for me to say.
Thank you very much for sharing your time with me and your comments. And I can't tell you just how much I appreciate the opportunity to take all of this in. So with all that
Todd,
being said,
thank you for having me, and thank you for all the kind words. I wish I could say them all back to you right now, but I know we're short on time, and I wanted to say I really appreciate you reaching out to me for the LinkedIn post. The words you said to me, inviting me on the show, mean a lot, especially coming from a guy like you. I respect the work that you do. I see a lot of folks now coming to me about civil rights violations, being on my side now, right? I'm in the private sector now, and those cases probably the ones that bother me the most. When there's an abuse of power, it needs to be brought out, and I thank you for the work that you do in that area.
All right, brother. All right, guys. Well, thank you. You had an opportunity to hear it from one of the best. Comment. Let him know what you think, what your thoughts are. Show him some love. It's a lonely job. Sometimes as a lawyer, you just need a big hug. So with that being said, all right, thank you guys, and we'll see you next time here on Civil Action.
We have to go to the root. We have to go to the cause. Dealing with the condition itself is not enough. And it is because of our effort toward getting straight to